Okay, it says, ma'am, I'm not too familiar with the Zoom. It says this meeting is being live streamed. Do I hit got it or don't leave meeting room, right?
There's nothing for you to do right now, sir, but sit right there, okay?
Yes. Do I hit got it? Because a thing popped up, ma'am.
Yes, that'll make the pop-up go away.
Okay, so you just hit got it? Just hit that button?
Yes, sir.
Okay.
Yes,
Thank
sir.
you. How
You're
you doing,
welcome. I'm good. How are you?
ma'am? I'm doing pretty good. Could be better.
I know. We're just waiting for the prosecutor to be out at the same time. I'll start calling cases. Our first case was scheduled at 9 o'clock. I'm ready to go as soon as the attorneys are ready.
Oh yeah, I'm sorry. I think I was a little early because I just got off. My boss said I come down there in the truck and
No, sir, I'd rather you be early than late. And thank you to your boss for letting you get to where you need to be.
Because I don't know how to work Zoom too good. And they one worker I work with explained to me, so I had to download the app or whatnot.
Sir, you are fine. You are in. This is the courtroom. We're here. We're ready. There are probably 2 cases ahead of you. We take the in custody cases first, and the one is scheduled at 9 o'clock. You're scheduled at 9:15. So sit tight. No, you're fine. Will you hear me? Will you hear me call your name? Respond, or if you see a request to go into a breakout room, that's because someone needs to talk to you. But other than that, you're gonna just stay there, be quiet, and just listen for your case to be called.
Okay. Thank you.
Thank you.
You're welcome.
And Mr. Hadley, I know you have something else to do. I'm being mindful of the time.
Sure. Good morning, Your Honor.
Good morning, Ms. Medina. How are you?
Good. How are you doing?
I am wonderful. Mr. Keats, your attorney has just popped into our waiting room.
And I just sent you an invitation, Mr. Bogus, to join me, sir. If you can.
Okay, I just hit join. I don't want to hit a button and then I get disconnected, ma'am.
Okay, no problem.
Hit join. Okay.
Ms. Silver, did you need to speak to Mr. Keats or Ms. Mandernock?
Oh yeah, there's Mr. Keats. He's waiting for his tether. No, we're just going to be asking for a new date. Mr. Keats.
Give me a moment when Madam Prosecutor pops out. Mr. Keats is the first case I'll call.
Thank you, no problem.
A new date, just an adjourned pretrial or a different?
Just an adjourned pretrial. I had expected that Mr. Keats would have been out. I had hoped to have a meeting with him in my office, but he's still waiting for a tether.
Okay, this is 220774 SM, State of Michigan versus David Edward Keats. Your appearances, please.
Good morning, Your Honor. Patricia Mandernack for the people.
And good morning, Gabby Silver, appearing on behalf of Mr. Keats.
Mr. Keats, state your name for me, please, sir.
David Keats.
Thank you. Today's the day and time set for the pretrial in this matter. Ms. Mandernack, before you joined us, Ms. Silver indicated she'd be requesting an adjournment.
That's my understanding, Your Honor. I believe APA Sona Morsisian is handling the felony cases, and they're anticipating some sort of global resolution.
Thank you. The adjourned pretrial date, Marianne, will be?
Is it gonna stay with the DV docket, or did I just hear something about state?
No, the state date is something different. It'll stay with this 34th District Court's DV docket.
Okay, May 23rd at 9:30, Judge Green.
Is that Zoom?
Yes, it is.
Okay.
This pretrial is adjourned to May 23rd, 2023 at 9:30 a.m. Courtroom number 3 with Judge Green by Zoom. Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defense?
Yeah, sorry, I was anticipating your question. I missed the time you stated for the 23rd.
9:30, ma'am.
Thank you very much, Judge.
You're so welcome. Anything else, Ms. Silver?
Not at this time. Have a great day.
You too. I'm sorry, Mr. Keith's tether has nothing, is it something that we need to do, or is it just procedural with the jail?
It's procedural with the jail. It takes some time once bond was reinstated for the tether to get put on.
Thank you, ma'am. Have a
Thank
good
you.
day.
You too. Thank you.
Thank you. Miss, what happened to Schmitz? Oh, Marianne,
Yes,
would you call Shannon, please? She has the Metzger file,
yes.
the schedule at 9:30. Thank you.
Your Honor, somebody may need to move Ms. Schmitz back in. I don't know if I've got the ability to do so from my phone. I'm trying, but not very successfully.
I'm trying. I'll see if I can get her in right now.
Thank you so much.
Are we ready on that file, Mr. Hadley?
We are, Your Honor.
It is 230141 SM, State of Michigan versus Schmitz. May I have your appearances, please?
Good morning, Your Honor. Patricia Mandernack for the people.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of the defendant, Ms. Holly Schmitz. Ms. Schmitz, please state your name for the court.
Holly Schmitz.
Thank you. Today is the day and time set for the final pretrial in this matter. Mr. Hadley, how are we proceeding?
Your Honor, after advising my client of her rights and speaking with the prosecutor, we are going to avail ourselves of the people's plea offer, whereby we will be pleading to the charge of domestic violence under delayed sentencing under MCL 769.4A.
Ms. Smith, raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You may put your hand down. You've had the opportunity to speak to Mr. Hadley. You understand the charges you face and the possible penalties.
Yes.
And after having that conversation, ma'am, it's your understanding you'll be tendering a plea of guilty this morning to the sole count in this matter of domestic violence.
Yes.
You understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or stand cross-examine witnesses put forth by the prosecutor.
Yes.
And ma'am, are you entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No.
Are you pleading guilty because you are in fact guilty?
Yes.
Ms. Schmitz, is it true that on March, I'm sorry. Mr. Hadley, before I inquire more specifically of your client, I want to disclose on the record, I know you're aware of this. I'm married to an elected official in Van Buren Township. I make the disclosure as Van Buren Public Safety Department is the issuing agency in this matter. My husband has nothing to do with the day-to-day operations of the Public Safety Department. He doesn't know that Ms. Schmitz's case is scheduled this morning. He has no input on how this court rules in any matter. Knowing that, do you need a moment to speak to Ms. Schmitz, or can we continue? Are we able to?
No,
continue
Your Honor,
on in this plea?
Please continue. We have no issue at all with that.
Thank you. Ms. Schmitz, is it true that on March 12, 2023 in Van Buren Township that you did commit an assault and battery upon Lawrence Lewis Smith, your spouse?
Yes.
Satisfied, Madam Prosecutor?
Satisfied, Your Honor.
Satisfied, Mr. Hadley?
Yes, indeed, Your Honor.
Ms. Schmitz, the court accepts your plea of guilty to the one count of domestic violence in this matter. As previously indicated by your attorney, this plea is being taken pursuant to MCL 769.4A, which means there is a deferred sentence in this matter. Ms. Mandernack and Mr. Hadley, was there any specific conversation regarding sentence in this matter? Any special request?
Your Honor, at this point, we'll leave it to the discretion of the court.
Mr. Hadley?
Your Honor, I concur with opposing counsel. We did not have any type of specific sentencing agreement. I would just note that this is a unfortunate situation, and we have a very compliant future probationer here. So we just ask this court to consider that.
Ms. Mandernack, are the people asking for anger management class or batterers counseling?
Your Honor, I would request that defendant complete. I would request that defendant complete batterers intervention. And actually, I'm sorry, Your Honor. Do you mind if I speak with Mr. Hadley very briefly?
Absolutely.
Okay, thank you.
Thank you.
And I think, Patricia, you'll just need to move me in there.
Okay. Judge, thank you for allowing us into that breakout room. I spoke with Mr. Hadley, and for the terms, the people would just request that batterers intervention be included.
We have
Thank
no
you.
issue with that at all, Your Honor.
Anything else before sentences imposed in this matter, Mr. Hadley?
No, Your Honor. Again, just what I'd kind of rely on what I'd stated previously. It's an unfortunate situation. It's not a violent individual, and her and the complainant have separated. There won't be any further contact. It doesn't sound like.
Thank you. The court will impose the following on Ms. Schmitz. There will be a $500 fine. There's $200 in costs. There's $75 mandatory crime victims fee. There's $50 mandatory state cost, $20 fund fee. The court will put you on 6 months of probation with the associated oversight costs. You'll be ordered to have batterers intervention, and you are to have no assaultive contact with the complainant in this matter during the pendency of this case. As indicated by Mr. Hadley previously, this sentence is being deferred once you complete that intervention program and pay the fines and costs associated. You incur no new criminal offenses in the state of Michigan, have no assault of contact with the complainant. The matter will be administratively dismissed. Understood?
Yes.
The probation department will be in contact with you regarding your payment plan and scheduling getting you enrolled in the batterer's intervention. Anything else, Ms. Mandernach?
No, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor, thank you for your time. Ms. Schmitz, if you have any questions after you meet with probation, please call me. Everybody have a great day.
Thank you.
Thank you. You too, sir. Good luck to you, Ms. Schmitz.
Thank you.
Judge Shannon is on her way up with the file.
Thank you, ma'am.
You're welcome.
That's a weird case scheduled for today.
She just called and said she put it on the wrong date.
She said what?
I'm sorry. Shannon just called and said she put it on the wrong date for today.
Thank you. Okay, because it's a show cause. And I said, there's no way that that's scheduled for today. Okay.
Hey, Patricia, it looks like Crystal's in your meeting room. The MIDC attorney.
Oh, yes. I will go there to meet with her.
Thanks.
Mary Ann,
Judge Martin.
I'm convinced we should bring the courtesy.
Oh, oh, I like that. They have it down, don't they?
I'm watching Queen Charlotte and I'm convinced that if we curtsied. Good morning, sir.
Good morning.
Your name, please?
Gerald Tennell.
Your case is scheduled at 9:30, sir. If you sit tight, we'll get you properly labeled.
Okay.
Sir, were you looking for the assistance of the court-appointed attorney this morning?
Yeah, if possible. Yeah.
She's here. She's in, I believe, with the prosecutor. We'll put you in her waiting room and get her in there with you as soon as possible, okay?
Okay, thank you.
Thank you.
Good morning, Your Honor.
How are you, Miss Oliver?
I'm all right, and you?
Good. What can I
That's
do
good.
for you?
I never want to speak out of turn, but I just want to say hi. I'm not sure when I should speak or not sometimes. But I just want to say hello.
You should always speak, especially when we have a lull in the action.
Okay, well, good. Okay, I know it's okay now. I just have all the different judges in the court, so some of them are a little bit more relaxed than others, I should say. So I just kind of get in sometime and don't say anything.
No, you and I chatting are a lot different than people coming back from the breakout and just start screaming out stuff. That's the time I have an issue. Other than that, if we're sitting here and I
Okay.
see Madam Prosecutor is back, but we're still waiting for the Ms. Medina to return. Was there something else, Ms. Mandernock?
No, Your Honor. I think we're just
Okay.
about to call Bogus as soon as Miss Medina returns.
Thank you. Thank you so very much. That's okay. Why are you on the break? Walking up the steps. I'm not sure you're in the elevator right here. I don't care. I'm just trying to be helpful.
How you doing?
This is
Oh, I'm sorry, Your Honor. I'm just,
Three.
I just want to make sure I call complaining witness in.
You're doing that right now? Isn't that how that works out? This is 230231 SM, State of Michigan versus Douglas Wayne Bogus. May I have your appearances, please?
Good morning, Your
Yes.
Honor. Patricia Mandernack for the people.
And Your Honor, Crystal Marie Medina on behalf of Mr. Bogus. Mr. Bogus, would you please say your full name for the record, sir?
Yes, my name's Douglas Wayne Bogus.
Oh, Bogus, sorry, sir.
Thank you. Today is the day and time set for the pretrial in this matter. Ms. Medina, how are we proceeding?
Your Honor, my understanding is that at this time, the people would be inclined to dismiss this matter. I will allow Ms. Mandernack to elaborate.
That is correct, Your Honor. I spoke with complaining witness who is present in the Zoom room today, and she indicated she does not wish to proceed with this case. Your Honor, if I may, I would request permission to very briefly voir dire complaining witness.
Absolutely.
Thank you. Ms. Bogus, you do not want to participate in prosecution for this case, is that correct?
That's correct.
Okay, is anyone threatening you to make this decision?
No, ma'am.
Do you have any safety concerns if the no contact order is lifted?
No.
Okay. Your Honor, the people are satisfied.
Ms. Medina, are you satisfied?
Satisfied, Your Honor.
Thank you. Inasmuch as the complaining witness, Ms. Tina Maria Bogus,
Bogus.
does not, Bodges, thank you, does not wish to proceed or participate in these proceedings further, the case is hereby dismissed.
Thank you, Your Honor.
All the conditions of bond are hereby released. Anything else on behalf of the people?
I'm sorry, Your Honor. I would just request that that be a dismissal without prejudice.
Yes, ma'am.
Thank you, Your Honor.
Anything else, Ms. Medina?
No, Your Honor, thank you very much.
Thank you. This case is hereby dismissed without prejudice. That concludes this matter. Good luck to the both of you. Have a wonderful day.
Thank you. You also.
Thank you. Mr. Metzger?
Yeah.
Sir, today is a day and time. Yes, is the correct response. Today is a day and time set for your show cause. It appears that you are you in treatment or in the hospital, sir?
Say that again, Your Honor.
I said, are you in treatment or are you in the hospital?
I'm in the hospital right now.
Your case was actually not scheduled on the correct day. It should have been scheduled yesterday on this court's regular probation docket. I do not like to proceed when someone's not really available. Do you
Okay.
know when your discharge date is?
No, I do not, Your Honor.
Were you prepared to proceed with this violation hearing today, or would you like the court to reschedule it to the probation docket, which our next hearing day, I think, is May 22nd?
Correct, Your Honor.
Mr. Metzger?
Say that again.
I said, are you prepared to proceed this morning, or are you looking
Oh, we
for
can
an
do this
adjournment?
morning.
We can put you,
We can do it right now, Your Honor. I apologize.
is there someone else helping you, or what's going on?
A nurse just walked in the room a second ago, but she kind of left.
Well, Mr. Metzger, there are allegations that you've not been compliant. The court would like you to have the opportunity to speak to the court-appointed attorney if that's what you wish to do.
No, ma'am.
You wish to proceed on your own with a violation hearing.
Well, I turned in all my stuff. Is it still a violation if I turned
Well,
all my...
hold on 1 second, sir. This is 220381. This is State of Michigan versus Blake Alexander Metzger. State your name for the record, sir.
Blake Metzger.
Thank you. Mr. Metzger, you and I started to have a conversation before the case was officially called. The issue is that you are before the court this morning for a violation hearing. This matter should actually be on the probation docket. Today's cases are domestic violence cases.
Okay.
So what I offered to you before the case was called was to reschedule this matter, and hopefully you will not be in the hospital setting and you are able to speak to the court-appointed attorney before you make a decision about how you'd like to plead to the alleged violations. This court's next probation date is May the 22nd. So the question to you is, would you like the case to be adjourned so that you have some time to possibly be discharged and we have the court's
Yeah, I would like to...
court-appointed attorney available?
Yeah, I would like to do that.
So again, sir, the next date is May the 22nd. I just need a time.
(9:30), Your Honor.
9:30, thank you. Mr. Metzger, we'll adjourn this matter to Monday, May the 22nd at 9:30 a.m. It will be back on Zoom, back with me. And sir, we have your address on Forest Court. Is that still a good address?
Yes, ma'am.
A notice with the new date and time will be mailed to you at that address, sir. When you appear on May the 22nd, there will be a court-appointed attorney here set to go over the alleged violations with you. You've indicated to me before the case was called that you've turned in the paperwork. That'll give the probation department a little bit more time to look into and make sure they've received that paperwork or follow up with you regarding what it is that they need. So I wish you a speedy recovery. I will see you on May the 22nd. Thank you.
All right, thank you, Your Honor.
Thank you, Judge.
Thank you, ma'am. So yeah, Marianne, I watched the coronation on Saturday morning, and I think if we had to curtsy to higher ranking people first thing in the morning, I think we'd be much more pleasant. The issue is who outranks who.
Judge, I was taught in law school that the clerk, they said the judge is the second most important person in the courtroom. The clerk is the most important person in the courtroom, and the judge is the second most important. So I don't know how that would go if we followed like coronation hierarchy.
Well, you've heard me make the disclosure that I'm married to an elected official, and so our ongoing conversation is who outranks who. And I see to him within the district, the city we live in, but everywhere else.
Oh yeah.
But yes, what we learned in law school is accurate. The clerk or the judge's secretary is a lot more important than the judge.
Oh yeah, they can save your butt or they can make your life awful.
And I'm sure Marianne's in there laughing, but it is true.
Oh yeah, I've had my butt saved by, especially when I first started out. I mean, they know more than I do.
I am in here laughing, actually.
Because
so you would wear the crown.
What I was practicing still, there would be clerks who would text or call and say, hey, this is a good time. This is not a good time. Where are you? Saving your butt.
Yeah. And I'd be like, oh, I definitely knew that I had this morning and I'm definitely not physically in another courtroom. Like,
and nobody talks to the judge. Everybody talks to the clerk. They're jockeying for position. They want the judge's ear when they can't have the judge's ear. And I can't come out on the bench unless Marianne's ready. And I always look for her first. I don't come out.
Hi, sorry to interrupt. Can I speak with you, APA Mandranak?
Yeah.
Sorry. Thank you so much.
Yeah.
You're not interrupting, Miss Medina. I'm stepping off until you two come back out.
Thank you so much, Your Honor. I was hanging out in the waiting room. Thank you.
Good morning, sir. Can you hear me?
Yes, can you hear me?
Yes, I can. What is your name, please?
You said what?
What is your name?
What is your name, sir?
Oh, Randall Royster.
Thank you.
Madam Clerk, do you know if Rima is there today or Mike Kazak?
Neither one, no.
Okay.
Mr. Royster, this is court. It might not feel like it because you're at home. So when the court is ready to call the case, I need you to not be eating, please, and thank you.
I'm sorry, I just woke up. My apologies.
Understood. Thank you, sir.
Does the backdrop matter? Can I step outside?
The backdrop does not matter at all, but if you wouldn't walk through these doors and do it, I need you not to do it while you're on camera, please.
I'm 100% sorry, ma'am.
No worries. Thank you, sir.
Mhm.
Yes, ma'am, that just joined us with the black scarf. Your name, please?
Carlina Davis on behalf of Michael Davis, Senior.
Thank
Here
you,
we
ma'am.
go. You're welcome.
Mr. Davis' case is scheduled at 9:45. We'll get you in with the court-appointed attorney here momentarily.
Thank you,
Okay.
ma'am.
You're welcome. Same thing to you, Mr. Royster. You will see an invitation to go into the breakout room with the court-appointed attorney here shortly.
What is that? Huh?
Hey,
You know, it'd be nice if they warned us that someone was gonna be on the roof, Mary Ann. That is very off-putting. This is 210361 SM, State of Michigan versus Gerald Tennell. May I have your appearances, please?
Gerald Tennell.
Yeah, sir, you're muted, AP Mandernack.
Oh, I'm sorry. I'm sorry.
Wait.
Good morning, Your Honor. Patricia Mandernack for the people. Standing in for APA Rima Yafufi or APA Michael Kazak.
And Crystal Marie Medina, Your Honor, on behalf of Mr. Tennell. Mr. Tennell is present, Your Honor, on Zoom. Would you please state your full name for the record, sir?
Gerald Tennell. Sorry about that.
Thank you, Mr. Tennell. Today is the day and time set for the arraignment and pretrial. This file had been in warrant status. Mr. Tennell has posted the $500 in from the warrant. The warrant is recalled. Ms. Medina, how are we proceeding this morning?
Your Honor, we would waive formal reading and stand mute as to the arraignment, Your Honor. With regards to the pretrial, we are going to be requesting discovery at this time, Your Honor, and another pretrial. If the court would like for me to adjust bond, I can do that as well.
Well, Ms. Medina, respectfully, in as much as Mr. Tennell has posted the $500, I would leave his bond at 5,010% with a no contact order to the complainants in these matters, Ms. Tatiana Streets and Angelina Streets, unless there was something else.
No, thank you, Your Honor. That would be great. And he understands he's to have no contact with the complainants in this matter, Your Honor.
Thank you. And I understand their relationship to him. So they're not in the same household, correct?
No, Your Honor.
Ms. Medina, the court's made the notation that you've requested discovery. Our next domestic date in this courthouse is on, I think, May the 23rd with Judge Green.
I'm sorry to interrupt, Your Honor. This is a, it looks like the charges here are assault and battery, not domestic violence. So this would be a non-DV misdemeanor, if that affects
How
scheduling.
did it wind up on this docket? No, so maybe a 2-week adjournment?
Your Honor, May 23rd, I have a,
I'm sorry, Ms. Medina, Ms. Mandernack has pointed out that although it's on the domestic docket for today, it should not be, it should be on the court's regular felony docket. So it would go on probably the 24th with Judge Oakley.
Oh. So that's a felony, miss, you said?
No.
I'm sorry. No. Mr. Tennell, it is a state case, not a I said felony, but it's not a felony. It's a state misdemeanor matter, which will put it on a Wednesday and not a Tuesday. That's more of a procedural court issue. I misspoke. It's a state misdemeanor matter.
Your Honor, is there any way I have a potentially, I'm not sure whether it's going to be the 23rd or the 24th, a homicide examination. So can I, on a routine case, can we do the 31st?
Absolutely. The 31st would be with a pretrial with Judge Green, May 31st at
9:15.
So again, Mr. Tennell, just so we're clear, that was my mistake. It is a state misdemeanor matter, which puts it on a Wednesday. Your attorney has requested discovery in this matter. The case is adjourned to Wednesday, May the 31st, 2023 at 9:15 a.m. That will be on Zoom with Judge Green. She's in courtroom number 3. Notice with the date, time, and the Zoom information will be mailed to you at the address we have on record, which is a DeQuinder address. And Warren, is that correct, sir?
Yeah, I just got something updated actually. I believe if it was earlier. I have an email. If you guys can, yeah, that I preferred.
I don't do the notices, Mr. Tennille, so I don't know if there's a preference. Mary Ann, do you?
Yes,
The notices just go in the mail, correct?
that's correct.
So, Mr. Tennille, you know that your next date is May 31st, so check your.
Yeah, understood.
Yeah, this
Thank you,
is
sir.
Good notice.
Anything else?
No, Your Honor.
Anything
thank you
else,
so
Ms.
much.
Meredith? Thank
No,
you.
Your Honor.
Mr. Tennille, thank you, sir. Have a good day. Good luck to you. Ms. Medina, have you spoken to Mr. Royster or Mr. Davis?
No, Your Honor, I am just putting them in my room now. I'm gonna take Mr. Davis into my room now.
Thank you, ma'am.
Thank you. Your Honor, I think Mr. Davis should be coming back soon, and Ms. Vanderneck, we are going to avail, he wants to avail himself of that offer you made yesterday evening.
Okay.
This is 230245 SM, State of Michigan versus Michael Roy Davis. May I have your appearances, please?
Good morning, Your Honor. Patricia Mandernack for the people.
And good morning, Your Honor. Crystal Marie Medina on behalf of Mr. Davis. Mr. Davis is present via Zoom and consents to be here via Zoom. Mr. Davis, would you please state your full name for the record?
Michael Roy Davis.
Thank you. Today's the day and time set for the pretrial in this matter. Ms. Medina, how are we proceeding?
Your Honor, the people have made us an offer that Mr. Davis has decided to avail himself of. The offer is for him to plead guilty to 1 count of domestic violence, is my understanding, under 769.4A, with a 1-year probationary term, a mental health evaluation and treatment as required, as well as batter's intervention. AP Manderneck, please let me know if I left anything out. Oh, the no contact would be changed to no assaultive contact, is my understanding, Your Honor.
Your Honor, that is a clear and accurate representation of the plea.
Thank you. Mr. Davis, raise your right hand for me, please, sir. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. You've had an opportunity to discuss this case with Ms. Medina, and you understand the charges you face and the possible penalties?
Yes.
And sir, after having that conversation with Ms. Medina, you wish to waive your rights to have a trial in this case and enter a plea of guilty to the sole count of domestic violence.
Yes.
You understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No.
Mr. Davis, are you pleading guilty because you are in fact guilty?
Could you repeat that?
I said, Mr. Davis, are you pleading guilty because you are in fact guilty?
Because I'm not that guilty?
Are you pleading guilty because you are guilty?
Yes.
Thank you. And Mr. Davis, before I ask you any other questions, Ms. Medina is aware of this, but I want to disclose on the record that I'm married to an elected official in Van Buren Township. I made that disclosure as Van Buren Township Public Safety Department is the agency that was involved in this matter. Ms. Medina, are we okay to proceed with this plea, or do you need to speak to Mr. Davis?
No, Your Honor, we have no issue with that. Thank you.
Thank you. Mr. Davis, is it true that on April 22nd, 2023, in Van Buren Township, you made an assault and battery upon Renee Davis, your spouse?
Yes.
Satisfied, Ms. Mandernack?
Yes, Your Honor.
Satisfied, Ms. Medina?
Satisfied, Your Honor.
Thank you. Mr. Davis, the court accepts your plea of guilty as charged on the sole count in this case of domestic violence. As previously indicated by Ms. Medina, your plea is being taken pursuant to MCL 769.4A. That means there is a deferred sentence in this case. Ms. Medina, was there anything you'd like to say before a sentence is imposed in this matter?
Your Honor, no, I think it's pretty clear, 1-year probationary term and the conditions that people are hoping for in exchange for the offer made in this case. Your Honor, I would just say that Mr. Davis was here timely, has accepted responsibility, and I would ask the court consider all of that.
Thank you. Mr. Davis, the court will place you on 1 year of probation with the oversight fees associated with that. The court will also order you into batterer's intervention. You are to have a mental health evaluation and any treatment that evaluation deems as necessary and appropriate. Your previous bond condition that you have no contact with Ms. Renee Davis will be changed to no assaultive contact. The court will additionally impose a fine of $500, cost of $100. There's $75 mandatory crime victims fee. There's a $50 mandatory state cost and $20 fund fee. Those fees will be payable during the 12th month of your probation. The probation department will be in contact with you. There will be other forms that need to be completed. They will also be in a position to help you set a payment plan for the fines and costs that have been assessed and to get that mental health evaluation and set up the batterer's intervention. Understood?
Yes.
Any questions, Mr. Davis?
No.
Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor, thank you so much.
Thank you. Mr. Davis, thank you for being so timely and appropriate this morning. You have a good day. Good luck to you, sir.
You too.
Here, Mr.
Thank
Davis. Your Honor, I
Mr.
will be
Royster.
bringing, sorry.
Go ahead.
I will be bringing Mr. Royster in with me now. I was just letting the court know.
Thank you. Mr. Royster, I was going to say to you, you should be seeing an invitation to go into the breakout room with Miss Medina. Please go there with her.
I haven't received anything. Hello?
You don't have anything on your screen that says join in the breakout room?
Sure,
No.
I just moved you. Okay, let me try one more time. Are you seeing something now, sir?
The host has moved you into, it said the host has moved me somewhere.
Yes, sir.
But
Go there.
how do hello?
Yes, sir.
Oh, there he is. Let me meet him quick. Thank you.
Thank you. Absolutely. I think you should wear that hat all the time.
I bought that hat 3 years ago and I saved it for this for Kentucky Derby party. The only reason I bought it, saved it for 3 years and went to the Derby party this year.
You have a good time?
Oh, of course.
Good. Yeah, I think you should wear that hat to work.
But that's court order. I'll make sure I do that, Judge.
Mary Ann?
Yes, ma'am.
So we're ordering Officer Crover to wear that hat every day.
I think it would brighten their spirits up there, wouldn't it?
I'll ask my judge too. Make sure.
Yeah, I don't think he'll go for that. Things are a little different in courtroom number 2. Ma'am, did you have any information about that 9:15? Sorry, 9:15 Marcellus Green matter? It was scheduled for arraignment and pretrial this morning.
Sorry, Judge, were you asking me?
I am asking you.
Marcellus Green.
Yes.
It looks like I sent discovery over. Let me see if we have defense counsel.
I'm sorry, sent discovery to whom?
That's what I am checking. I have defense counsel listed as Crystal Medina.
Not on Marcellus Green.
Oh, then that is a typo on my part.
Because Mr. Green has not been arraigned as of yet.
Oh.
Unless you sent discovery proactively to.
I thought it was Miss Medina, so I sent it proactively because I had it listed as a pretrial.
No, it's 230228 SM State of Michigan versus Marcellus Lamar Green. It was scheduled for arraignment pretrial at 9:15. It's now 10:12 by this court's clock. I don't see that the court had any contact or communication with Mr. Green beyond sending the notice to appear this morning. The warrant in the file was authorized on April 11, 2023. But he's not here this morning, and inasmuch as this crime is assaultive in nature, the court's inclination, this is a second offense notice DV case, the court's inclination is to issue a bench warrant for $5,010 unless you have some other information update or a different request.
No, Your Honor, I do not have any additional information, and I agree with the $5,000 with the revocation of bond and the new bond being $5,000, 10%.
Thank you, ma'am. Did I just hear Christine?
Yes, she was walking down the hall.
Oh, I'm curious if they're going to plant in the garden again.
Can we, sorry, Judge. I am sorry again to interrupt. I just wanted to see if APA Mandernack can meet me in her room at her earliest convenience. I will be waiting for her.
Thank you, ma'am.
Thank you, Judge.
We had to show cause him. The failure to comply has to be show cause first. Okay. Is he calling? No, that's not what he said. I need to file, because we need to schedule it for show cause. I want him to come in person, Mr. the other guy.
But the other guy failed to appear.
He appeared, he wouldn't comply.
Oh,
So the show cause is the intervening step before the bench warrant.
oh, so he did, okay,
He-
okay. I read something like that on. I read something like that on.
Yep. Marianne, I'll be right back. Hold on. No, it's fine.
never been in this part. I have. That's why I told Mary,
Oh, I just, that door is closer to my desk, that's
yeah,
all.
okay.
Uh,
It's smaller though, it seems smaller than I.
it's okay, it doesn't need to be big.
Yeah, that's nice.
To civil. To schedule show cause.
Okay, now I gotta call him back and he's gonna go crazy.
No, that's because you can't go straight to bench warrant. You have to have an opportunity to be heard. Show cause for our 6/6
So called.
docket.
Okay,
I don't care what time.
okay,
Parties to appear in person.
okay.
He appeared, but he did not comply, so you
didn't
have to
comply,
have an
okay.
additional opportunity to comply. And you can
Okay.
tell Mr. Williams, that's me, that's on me, that's not on the court, that's not on the civil department, that's on me.
Okay. Yeah, he was, yeah.
I know, that's
thought
why
he
the
could
file's been
issue
on my
bench warrant.
desk.
That's right, okay.
No, you can't because he physically
And
appeared, he
did
just didn't
appear,
cooperate.
And I thought he did, okay.
No.
All right, thanks a lot, Judge.
You're welcome.
Appreciate it.
No worries. It's an older case, so it's not, I'm not,
Yeah, yeah, since the 21 case, yeah, yeah. All right,
okay, thank you.
thank you.
All right, Yana, I'm about to log off. I have to get to Lincoln Park by 11:30.
Understood.
All right, I will see you in the morning. You have a good rest of your day.
You too, ma'am. Thank you.
Thank you.
Bye-bye.
Bye-bye.
I do. Oh, joy. Who saw that coming?
Hi, Judge. I apologize for the length of that. That was my fault. I believe Miss Medina
No
is
worries.
her client, and then we'll be right back.
Thank you. Good morning, Mr. Richards.
Good morning.
The court has received an appearance from Mr. Stidham on behalf of J&T Towing. This case is scheduled at 11 o'clock. Ms. Medina, Mr. Royster appears to have left.
Oh, he should. Your Honor, he was trying to leave the breakout room, not leave. So, were you guys going to go on the record on anything? Or Ms. Mandranak, are you available while I'm waiting for him to come in really quickly? He gave me some more info, I think I should advise you of.
This might be him coming in right now.
Okay, thank you.
Are we ready with the case, Ms. Medina?
Ready, Your Honor.
This is 230264 SM, State of Michigan versus Randall James Royster. May I have your appearances, please?
Good morning, Your Honor. Patricia Mandernack for the people.
And good morning, Your Honor. Crystal Marie Medina on behalf of Mr. Royster. Mr. Royster, would you please state your full name for the record?
Randall James Royster.
Thank you. Today is the day and time set for the first pretrial in this matter. Ms. Medina, how are we proceeding this morning?
Your Honor, at this time, we have received paper discovery. We are waiting on some digital discovery. We would ask that the matter be set for a final pretrial, at which the complainant would be asked to appear, Your Honor. We do have some concerns in this case with regards to the complainant's contacts with my client, Your Honor. So it's just something that I'm going to follow up with Ms. Mandernack as soon as possible.
Thank you, ma'am. The court will note the file that the digital discovery remains outstanding. The final pretrial where the complainant must appear will be May the 23rd, 2023 at
9:45.
At 9:45. That will be in courtroom number 3 with Judge Green on Zoom.
Your Honor, I apologize. I mean, I could ask somebody to stand in for me, but again, I'm not sure if that day or the following day is when I have that big preliminary exam. So I'm not sure if we could do another date so that I can follow the case.
We absolutely can do another day after that May 22nd. The June domestic date will be on June the 13th.
Give me 1 second to find it.
Yes, ma'am.
Judge, I do have a jury trial at 30, a misdemeanor jury trial at 34th scheduled to go on Monday, but I don't believe that it would go into Tuesday, or if it does, I would be able to run in very quickly to handle this matter.
At 9 o'clock, Judge.
Thank you. Final pretrial where the complainant must appear June the 13th, 2023 at 9 a.m. That is on Judge Oakley's docket, which makes it in person. Mr. Royster, live appearance on June the 13th at 9 a.m. Notice will be mailed to you at the address we have on record, sir, that has you on Eileen in Detroit. Is that still a good address for you, sir?
That's fine, ma'am.
If there's a better address, Mr. Royster,
Excuse me?
if there's a better address for you,
It isn't no better address, ma'am. I'm going through hell not seeing my children, so I would like to get to the bottom of this at earliest convenience.
understood, sir. Anything else on behalf of the people?
No, ma'am.
No, no, Your Honor, just to confirm, that is in person, you said, on June 13th at 9 a.m.?
Yes, ma'am.
Okay, thank you.
Thank you. That concludes this matter. I'm sorry, Mr.
Your
Royster,
Honor,
were you saying something?
I got a question for you before I get off this phone. Like, I'm still kind of confused. So I'm not trying to bring up the previous court that you just had. You had said, asked him something about the date of the 28th, the date of the 28th when the incident occurred.
Sure. We're not going to get into anything right now on the record, sir. You have the absolute right to remain silent. Please, we're not going to be speaking directly to the judge right now, although it is a pleasure to speak to Judge Martin. It's not something we're going to do.
Mr. Royster, Mr. Royster, listen. I didn't say anything about the 28th because Ms. Medina is just cautioning you against saying something that could be used against you, even though from your perspective, it might feel like it's necessary to say, it might not necessarily be helpful to you. If you have a question, a procedural question about something that's happened today, I'm happy to respond to it and explain it from that perspective. But if it's about what happened when this offense occurred,
I don't know when the offense was occurred or made or anything. Like, I'm blindsided. So it is.
So now, Your Honor, if I may, sir, you have my telephone number. Please contact me. We're going to get together and go over all of the discovery in detail, okay?
All right.
thank you. Mr. Royster, good luck to you, sir. Have a good afternoon.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
And that concludes this court's domestic docket for the day. Our next case is 11 o'clock in the civil case. So thank you both for your assistance this morning.
Thank you, Your Honor.
Thank you, Judge.
AP Mandernack, if I could just see you 2 more quick seconds before you leave for the morning, please. Yeah, I'm a little bit concerned on that. Thank you. Thank you, Your Honor.
You're welcome. Mary Ann, we'll leave our Zoom up and running because we'll flow right into the 11 o'clock once Mr. Stidham appears.
Thank you.
Oh, have a good one.
Awesome. Councils, do you need to go in a breakout room or are you ready for the judge?
I think, am I the only lawyer on the call?
No, Mr. Stidman is here.
Oh, okay. Yeah, that would be great if we could do that briefly.
Okay, sure.
There's also, there may be someone from the Michigan State Police is supposed to join as well. I don't know if she's gonna be here. Her name is Beth McLaughlin. But hopefully she will join.
Okay, as of yet, she's not here. If she appears when you're in the breakout room, I'll put her in with you guys.
Okay, thank you.
You're welcome.
He's on location. 2018 on location.
Hi, the person who just signed in, what is your name, please?
Laway with Nationwide Recovery. I'm sorry, J&T Crova Towing.
Okay, hold on one second.
This is 232084 GZ, Axel Lopez versus J&T Towing. May I have your appearances, please?
Good morning, Your Honor. May it please this honorable court, Ray Richards on behalf of the petitioner, Axel Lopez, who it's my understanding is appearing via Zoom and is muted at the present time.
Good morning, Your Honor. Thomas Stidham appearing on behalf of the respondent, J&T Towing, and with me today is its principal, Louis Hussein.
Louis Hussein, J&T Crova Towing.
Thank you. Today is the day and time set for hearing on the petition. The parties have had an opportunity to speak. Mr. Richards, have you and Mr. Stidham reached an agreement or resolution of this petition?
Judge, at this time, we've made great efforts to do so. I think we have a understanding of the positions of both parties. The issue here is, Judge, not cost of the towing, but the actual status of the vehicle. The vehicle currently is not in the possession of J&T Towing, and they were very forthright enough in disclosing that they did not have the vehicle anymore. It was taken by the Michigan State Police 6 days after the notice of abandonment was filed and sent to my client. So it had been in the possession of J&T for 564 days without any notice to Mr. Lopez. Mr. Lopez writes a letter to Ally, who is who the financing was done for the lease. After the letter from Ally, all of a sudden the abandonment notice comes from the state of Michigan, albeit.
I'm sorry, Mr. Richards. Maybe I misunderstood you. I thought you said that MSP took the vehicle from J&T 6 days after the tow.
No,
go ahead.
No, 6 days after the notice. It had been with J&T for 564 days. Okay. And then after the notice of abandonment was sent to my client, 6 days later, the MSP took the vehicle from and moved the vehicle to the Brighton Post and took it from the J&T Towing. And I guess they're still saying it's there for investigative purposes. So in a sense, Judge, J&T, they don't have the vehicle anymore. J&T, I guess their exposure in this is limited at best under the circumstances because the MSP paid the costs of the tow or the lodging of the vehicle and moved it into their actual custody. So the only question now, Judge, is did in fact Ally place a lien on the vehicle of Mr. Lopez during this period of time that the vehicle's been in their custody? Now, what's interesting, Judge, is Mr. Lopez has paid the car note or the lease note on this vehicle for 19 straight months up until last month. So at this point, for them to say, MSP, to say it's abandoned is a bit disingenuous. But Judge, we understand that, and we have to admit that the vehicle can be retrieved or can be taken from Mr. Lopez if it's a part of a criminal investigation. Now, the part of it that's interesting, Judge, is it's been more than 19 months, and it's a situation where Mr. Lopez is 20-some months in payments and with nothing to show for it. So that's why we're challenging this, Judge, just to get a status of if it's still a part of the criminal investigation, to let it be known and at least, I don't know, somehow make sure Mr. Lopez's credit isn't affected because he's been bound by the agreement with Ally. It's just this wide-ranging investigation with this vehicle that has gone from Taylor, Michigan to Brighton, Michigan now. We want to know exactly what's going on so it won't ruin his credit. Because that agreement with the Michigan State Police, he had no agreement. They took it under the guise of it being an investigation. So it's really not much he can do, but we have an issue with the whole time it's been there. After phone calls to the MSP from Mr. Lopez and myself, and nothing. But as soon as Ally went to move to, hey, what's going on? All of a sudden they spring into action. So J&T in this, Judge, just is doing, and Mr. Stidham and I had two good conversations about this. And I understand this position. His client works for them, and he moved the vehicle when they requested it. They can do that. So, so as far as the resolution is concerned, it may resolve itself if Ally, one way or the other, gives notice as to if they put a lien on the vehicle and effectively relieve the rights of Mr. Lopez pursuant to that clause in that lease contract that says they can take the vehicle to vehicle's been part of a police investigation, which allegedly it is.
Your Honor, may I just respond to that? And my client can offer some, I think, more recent information. But first of all, I just want to point out real quickly that the vehicle was subject to a hold initially because of this alleged, it was involved in some way, shape, or form in a shooting. The hold is obviously placed by the Michigan State Police. And to our knowledge, and my client will talk about this in a second, the hold has not been removed by the Michigan State Police. The second thing I wanted the court to know is the storage fees. As counsel correctly stated, the vehicle was held at J&T for 564 days at $20 a day, which was $11,280. And J&T was never paid for that amount. J&T, Mr. Hussein can confirm this, waived that amount, was required to waive that amount, I believe. And lastly, Mr. Hussein did endeavor and has reached out to the Michigan State Police to try and assist the petitioner. And if the court would permit, I'd like him just to address the court with the most recent information, because he's been the one directly in contact with them, if the court would permit that.
Any objection, Mr. Richards?
No objection, Judge.
Go
Mr.
ahead,
Hussein.
Mr. Hussein. You have to unmute yourself.
Yes, sir. So I tried reaching out also to the attorney before I got my attorney involved. We couldn't get a hold of him, but the vehicle was entered into A-band in error. It should have never been entered into A-band, and that A-band was canceled right away. So even though it triggered all these notices that went to the owner of the vehicle and to the finance company, nothing else has changed with the vehicle and its status. It's still under police hold. Whether it stayed in our custody or the state police's custody, the fees were going to be waived no matter what. That was at our discretion. The state police was willing to pay for it, but we, when it's a victim vehicle, we do waive the charges. So he has no charges for it. He is still entitled to the vehicle. Since he is making the payments, that's what I was trying to notify his attorney. Since he is making the payments on it, the state police is not going to release the vehicle to the bank. He's got first right to go pick up the vehicle. If the bank does pick it up, he could retrieve the vehicle from the bank, since he is continuing to make the payments on it. And the state police is just, his lawyer will have to communicate with the state police as to when the prosecutor's hold comes off of it and the case is over, for him to retrieve the vehicle. So really, there's no petition. His vehicle, no one has taken his vehicle. It's just on hold with the state police. And when the state police removes that hold, he should be entitled to his vehicle. I don't believe Ally, the department that called, is like a generic department. Once they got that notice, it triggered them to call the state police and say, hey, we're the owner, we want the vehicle. But if his attorney needs to call Ally, let him know that he is up to date on the payments, he will be retrieving the vehicles, and he is going to handle all fees if there is any, but the fees are waived.
Mr.
And
Hussein,
that's all that needs to happen here. There's not much more to it. And I verified all that with the state police.
The question I have is, the abandoned notice was in error. Was notice of the correction sent to either Mr. Lopez, his attorney, or Ally to undo some of what has been triggered?
Yeah, the state police did notify him that it was still on hold and the A-band was in order, was in error, Ally did. I believe the state police said when they did try to talk to the attorney, there was some kind of argument or misunderstanding on the phone, so they couldn't communicate properly. But I'm here to tell you that there is no A-band notice. The Brighton Post for the state police has the vehicle. They do have the information, the detective's information that is in charge of the case, and there is no charges on the vehicle at all. So he's not liable for anything other than the payments he is making on the vehicle while it's on hold.
Mr. Hussein, here's
Yes.
the issue. Well, here's the next issue. You are not under oath, so right now you're just talking.
Oh,
And if,
yeah.
and if
No
Mr. Hold
problem.
on, no, sir, that doesn't mean talk. Mr.
Okay.
Richards is shaking his head, meaning that there has not been a correction to the improper, inaccurate abandon notice. So the petition is properly before the court this morning, unless Mr. Richards and Mr. Stidham, you propose a different way to proceed. Notice was sent to Michigan State Police by this court on April the 27th for them to appear this morning so that we could have real-time information regarding the status of this vehicle. I know I saw that notice. Yes, a copy of the notice was sent to the South Post on April the 27th, and Mr. Stidham indicated that he had been was expecting someone from MSP, but it's now 11:20 for this 11 o'clock case, and this court hasn't seen anyone from MSP. So, Mr. Richards, how do you want to proceed in this matter this morning?
Well, Judge, a couple of things just to set the record straight. My first time conversation, actual conversation about this vehicle and with some substance was maybe a week ago. And that was with the trooper that was supposed to be in court today. I believe her name was placed on the record, and the detective Stansky or Stelsky, something of that nature, starts with an S, of the Taylor Post. I spoke with the detective, let the detective know what the situation was. He advised me, Judge, that a risk loss person from Ally was in touch with him, and that there was a lien on the vehicle, and that it was Ally's intent to take the vehicle back once the investigation was over. So I asked the detective, well, can you send that to me so we can obviously review it? He tells me no, that we have to go to Ally. And I said, okay, as a lawyer, I after 26 years, Judge, I know better than, to speak with potential witnesses. So that's when he and I had an exchange. It wasn't anything outrageous, but at the end of the day, I did tell him that, hey, you need to appear for the hearing so we can figure this out because we have no notice. Mr. Lopez then that same day reaches out to Ally and says, hey, what's the status of my vehicle? And Ally, they tell him, hey, we will send you, there's a lien, and we will send you proof of that via fax to your lawyer. And he gave you the fax number and also sent it to him via mail. I haven't received the fax. My client has not received anything in mail. And so we're at a point, Judge, it kind of reminds me of the former President Ronald Reagan, when it was a situation where it was a Gorbachev situation was going on. And they asked President Reagan and said, well, we know you have a peace treaty. Why are you still asking questions? And Ronald Reagan said, we trust, but we also verify. So in this situation, that's all we're doing, Judge. If they have a lien, we move on. If they don't have a lien, then we kind of need to figure out how we're going to get this vehicle back that he's still making payments on. And if in fact this is a victim hold, as Mr. Hussein says that the Michigan State Police told him, they haven't notified the victim of the status of the investigation since its inception 564 plus days ago in this case. So I really don't know what remedy. I have no issue with JNT towing. They've been more than forthcoming as far as following up on their end. It's just a situation of Ally, who we also sent notice to, and they didn't respond and didn't appear today. And the MSP releasing some information to make things a bit more clearer to us so we can verify and then take the next step.
Your Honor, if I may, I would suggest that perhaps the matter be adjourned to permit Ally and and or the Michigan State Police to appear. And I know I heard the court say that notice was sent to them, but perhaps if it went to Metro South, I don't know what happened, but certainly I would believe if Ally and MSP were here, the matter would be able to be resolved, or at least some information shared that may assist the parties in resolving or assist the petitioner.
I would have no objection to that, Judge.
Thank you. Here's the issue. I don't see the notice was sent to Ally, although the petition filed by Mr. Richards lists them as a necessary and secure party. I guess there is concern that both of you seem to have spoken to MSP, but they absent themselves from these proceedings this morning. Our next civil date, and I hate to push this out that far, our next civil date would be June the 6th. Mr. Lopez has already been 19 months without this vehicle, and I don't want to belabor it, but would June 6th be too far for you, Mr. Richards?
Judge, if that's the next available date, we could definitely, if we could do it by Zoom, that would be great. Would that be possible?
Absolutely. I always do it by Zoom unless you ask to be in person.
No, Zoom works better.
Can I make it just a quick recommendation?
No, sir, absolutely
Okay.
not. I don't know where this yelling out stuff comes from. No.
Sorry.
You can talk to Mr. Stidham if there's some concern you want to relay, but we don't do that in courtroom
All
number
right,
one.
Tom, I'm exiting the call. Have a good day, ma'am.
We'll put this matter over to June the 6th at 11 a.m. The civil department is sent notice to the Taylor, which is the MSP Metro South Post, as they are the law enforcement agency on the notice of abandonment that was sent out previously. So we'll make sure that Allied, MSP, J&T, and the attorneys of record receive notice of that June 6th at 11 a.m. back in number one, back on Zoom, notice to attorneys, parties, Ally, and MSP. But the issue, if the issue is not reasonableness of fees and the vehicle being deemed abandoned, I'm not sure what the order is crafted to look like to get Mr. Lopez the relief he's seeking. Because if it was incorrectly labeled as abandoned, but not really abandoned, but no new notice, is it still abandoned? How does it look if you run the vehicle? Does it list as abandoned, or does it list as victim hold? So it's.
Well, Judge, I would say this. If it's a situation where the abandonment was revoked, I mean, obviously Mr. Lopez and I didn't receive notice, but obviously the court didn't receive notice as to the abandonment or the revoking of the abandonment either. I'm sure that if it received notice to abandon the vehicle or deem it abandoned and petition for Mr. Lopez to show, I'm sure that same courtesy should have been given to the court to unabandon, I guess if that's the correct term for it, or revoke that order or request. That didn't happen as well. So again, we understand the representations, but yet we can't verify it. So.
But Your Honor, I can just say in response to that in my experience anyways, I've never seen, and I've had other situations where for whatever reason, the abandoned notice was improperly issued or untimely issued, or, something was out of the ordinary. And in my experience, maybe it has to be re-abandoned. I have seen that, but I've never seen, at least in my experience, I've never seen a law enforcement agency issue a notice like correcting, or saying that it's no longer abandoned. I'm just saying.
Mr. Stidham, I understand that, and please convey to your client, I was not trying to be rude or disrespectful to him, but this does not appear to properly be here. There's something else going on, and there's some concern that although you're saying the MSP doesn't send a corrected notice saying not abandoned, there has to be something. If not a formal notice, at least some confirmation so that Mr. Lopez is out of this. Is
Sure.
there a lien? Is there not a lien? Can I get the vehicle? You're done with your investigation. Whatever it is, there's something that will get it off of this court's GZ docket and get it back where it belongs, whether it's Mr. Richards fighting with Ally on behalf of Mr. Lopez and your client being out of it or something, but this is not it. This with MSP not appearing, Ally not seeming to be in good communication with their customer, there's something else beyond abandoned vehicle.
Right.
Anything else this morning, Mr. Richards?
Nothing else, Judge. Thank you.
Anything else, Mr. Stidham?
No, Your Honor. Thank you.
I'll see you on June the 6th at 11 a.m. If in the interim, you all have conversations with each other or MSP and you resolve the matter short of returning, please just submit that signed settlement agreement, settlement order to the civil department. Or if there's a better place we should send it for MSP than the South Metro Post, let the civil department know so that all necessary parties are here on June 6th. Other than that, thank you for your patience this morning. You both enjoy the rest of your day.
Thank you. You as well.
Thank you.
Mary Ann, that concludes our docket. This court stands adjourned.